Well, we talked about last week how Disney was trying to argue in a lawsuit claiming that they were responsible for the death of a guest as they had allergies and they visited a restaurant at Disney Springs and they were served food that they're allergic to and then died from that. The widow of that woman was suing Disney for wrongful death. Disney was claiming that they couldn't sue them because they had signed up for a Disney Plus subscription. And in the terms and conditions said that any disputes would have to go to arbitration. Well, Disney, and I'm in my opinion, rightfully so, got a lot of backlash about this. And not to mention the sort of precedent that this would set going forward with major corporations and what they could put into terms and service agreements and just get away with basically whatever they wanted to. So it seems Disney has had a change of heart in this matter. And we're going to read an article from Deadline here about this. So, hi, I'm Jared with Capture the Magic. And the headline here is Disney waives arbitration and allergy death at restaurant in Orlando Park. Matter can, quote, proceed in court. Disney is waiving arbitration in a wrongful death suit filed by the husband of a woman who died at a dining restaurant at Disney Springs Resort in Orlando last year. His name's Jeffrey Piccolo, is suing the company for $50,000 because his wife suffered an allergic reaction after consuming food at the privately run Raglan Road Irish pub in October and later died at a local hospital. Disney's attorneys had requested that the case be dismissed and settled out of court. Basically, he's claiming because he had a Disney Plus subscription that put that in the terms of service. Raglan Road is a restaurant tenant at Disney Springs, not owned or operated by Disney. While Disney Parks and Resorts argued that by signing up for a 30-day trial of Disney Plus in 2019, and again when purchasing the theme park tickets in 2023 through his Disney Plus account, Piccolo agreed to the streamer's terms of service, which includes that, quote, all disputes with the Walt Disney Company or its affiliates be settled out of court via arbitration. Now, the company has waived that arbitration and will, quote, have the matter proceed in court. Disney said it is in the process of submitting the waiver withdrawal filing in court. At Disney, we strive to put humanity above all other considerations, Disney Experiences Chairman Josh D'Amaro said in a statement. With such unique circumstances as the one in this case, we believe this situation warrants a sensitive approach to expedite a resolution for the family who have experienced such a painful loss. As such, we've decided to waive our right to arbitration and have the matter proceed in court. Piccolo's lawyers have said that Disney's terms of service argument bordered on the surreal and is, quote, is so outrageously unreasonable and unfair as to shock the judicial conscience. It says, in effect, his attorney said Walt Disney Parks and Resorts is explicitly seeking to bar its 150 million Disney Plus subscribers from ever prosecuting a wrongful death case against it in front of a jury, even if the case facts have nothing to do with Disney Plus. The complaint states that the family told their server repeatedly about his wife's food allergies, and they were assumed that it would be okay. So basically what's happened here is Disney got a lot of bad press about this and decided we're not going to go the arbitration route. And the reason they would want to do this is because trials typically don't go the best for large corporations. A lot of times they tend to lose on those. Arbitration is much more, business corporation friendly, as that's typically like a retired judge or former judge that is going to be the arbitrator and then trying to make some sort of, judgment on the case. Obviously, it's a lot cheaper to go this route. So it's hard to know which way this went, if this was just the lawyers decided to do this and they really didn't, talk with Disney about the potential PR nightmare this was, which it did turn into a PR nightmare because a lot of people were talking about it all over the internet. And it's just gross. A guy lost his wife and they went to that restaurant because that restaurant had many times talked about they were very allergy friendly and were, would take the proper precautions. So, and it's just, it's an unfortunate situation on top of the fact that all they were suing for is $50,000. $50,000 to Disney is not much money. So the fact that they wouldn't even look at this and they wanted to go to arbitration, it just all is a really bad look for Disney. So I'm not surprised to see them sort of, going back on this and saying, we're going to allow this to go to court. I would assume that this would end up being settled outside of court for a sum of money. But the fact that Josh D'Amaro actually came out with a statement here is pretty telling because he's typically sort of the face, especially of the park side of things, of if they want things to be received nicely, they put Josh out there to sort of put that word out. So I guess on one hand, I'm glad that they've decided not to go this route. Now, one thing that because of this could give other companies an idea to try this, considering that this wasn't, there's no court case that they could look at and say, no, you can't use this. It was just dropped by Disney because more than likely it was going to get thrown out. But again, this does put the seed in the thought of many companies, I'm sure, to tuck in to their terms of agreements of certain things like this. But I think it's rather ridiculous to assume that if you sign up for a Disney Plus account and then you bought theme park tickets through that account, that you go to Disney and something like this unfortunately happens, that you would have no recourse legally because you signed up for a free trial. That is, I don't know how to put it into words other than completely asinine, and something that I truly hope is forever out of the idea of these companies, because it's just a gross thing. It's just something that is, and I agree with the lawyers of him saying this, like, it's surreal, like this is an insane argument basically. So I'm glad that this is proceeding this way. Hopefully this is the last of these. Probably not, though. If I were to guess, in corporations, they're going to try and stuff some of this stuff in there. But it seems, at least in this case, Disney has decided to change course and allow this to move further to trial. So I guess we'll have to wait and see what ultimately comes of this. Again, my guess is they do an out-of-court settlement. But either way, at least for the time being, just because you sign up for a Disney Plus subscription doesn't mean you can't sue them for wrongful death. But I suppose going forward for other things, I guess they hold that right to be able to use this argument if they want to in the future. But that's going to be it for this video. If you like this video, please like it and subscribe to the channel, as we do lots of coverage here of Disney World, Universal Studios, Epic Universe, and pop culture news. And let us know in the comments, what do you think about all this? And do you think that other corporations are probably going to try this defense in the future going forward? And until next time, we will see you later.